Good morning, everybody. No mai, haere mai, ngā mihi nui. Welcome to those who are watching our submission phase of the proposed Gore District Plan. It'll be my intention to have an informal process while still observing the requirements under the RMA. My name is Cliff Bolger. I'm your chairman, and my involvement has been through the Gore District Council, a previous council for some time, and a hearing commissioner. And I'll hand over to the other panel members to introduce themselves.
Thank you, Cliff. Keith Ovell, Deputy Mayor and also Chair of the Council's Policy and Regulatory Committee.
Kia ora, good morning. Glenys Dixon, a councillor, third term councillor and the Chair of Community Wellbeing Committee.
Tēnā koutou. Rangatira mā mana whenua, kai mahi hāpori, ngā mihi nui, ko whare papits maunga, ko motueka te awa, no motueka hou, tapanui, taku kaika naine, Maria Bartlett, tōku ingoa. Kia ora, I just was greeting all those who may be listening and watching this morning, including any Ngāi Tahu whānau who may be online, and to all of the community who are listening and watching today. I am an independent hearing commissioner with a varied background and looking forward to being a part of the hearing today. Kia ora.
Thank you for the blessing, Maria. I'll hand over to the Council Reporting Officer and legal people to introduce themselves. Thank you.
Kia ora koutou, ko Matt Hill, tōku ingoa, he kai whakamahaere mātua hou, no Waitakere hou, no reira tēnā koutou, tēnā tātou katoa. My name's Matt Hill. I'm a principal planner at the property group. Key part of my role has been leading the review of the Gore District Plan. Thank you.
Tēnā koutou, ko Shelley Chadwick tōku ingoa. I am here as the lawyer for the council to assist with any legal issues as we proceed today.
Thank you. Just to remind people that the everything is live streamed, and those recording of the proceedings will be available on the website. I wish to introduce Ms. Crazy Wolf, who is our administration officer and doing a fantastic job. I'll just do some basic housekeeping for those people. The emergency exit will be the exit that you used when you came in. And of course, there's toilets around to the right, which you'll have access to. Just a note or a minute, if you like, has been given to give those who wish to be present as submitters some guidelines as to how what would be correct behaviour in making a submission. I would remind submitters that, and for those people watching, that submitters should be addressing their comments to the chair, and the panel won't be allowing any debate between submitters or direct questioning of the reporting officer. And and that minute is also available on the website. As I said, it's my intention to run a fairly informal process. I'd like to acknowledge the submitters that all the evidence has been read and we're familiar with it, and we expect that when people are giving their submissions that they will, we anticipate that they will be covering the bulk of their submission with a summary, and we may have some questions of clarification. Before we kick off, just to acknowledge that there is for the panel members, a register of potential conflicts, which is on the website, and I will ask before each submitter if any of the panel members feel that they are compromised in any way over that particular submission or item. And I guess for the final question I have for those present, are there any procedural issues that we should consider before we start the process?
Nothing for me, thank you.
Okay, thank you very much. I will now hand over to the first group that we will hear from will be the property group and Anderson Lloyd to run down some of the, not concerns, but in fact I should remind that the topics will be the general planning issues, the plan in general, the introductory chapters, and urban form and development. I'll hand over to the property group. Thank you.
Kia ora. Thank you for that. So I was going to be up first just to cover the legal submissions which were filed, and hopefully you have a copy of legal submissions of council. And I'm assuming that you've probably read them, so don't want to hear them again. So I'm happy to speak to them. I did want to make one correction. I apologise, there's one error at paragraph 13. The final sentence there was talking about new NPSs, but without the word new, it doesn't make much sense. So I apologise for that. It's probably best just to strike out the whole final sentence there.
I'm sorry, would you repeat that for my benefit, please?
Sure. So paragraph 13, the final sentence of that paragraph, which starts, "There is no legal imperative." Just strike that whole sentence. The content is in the remainder of the paragraphs.
Thank you. Proceed.
Thank you. What we've endeavoured to do here is just assist with providing an overview of the decision-making requirements for you as a panel, just to run through for each of these topics as you go through the district plan review. It's a bit of a dry description of the requirements of the RMA for your decision-making. There is a couple of comments in terms of the current regulatory environment, which is usually the case with RMA. The RMA, it's in a bit of a state of flux, and there's always things coming and going. So probably that part of the comments about that are at 4, 5 and 6, and the submission there is that you are obligated to apply the RMA and national direction as it is on the day of the hearing. And then if any changes come in, they will have specific commencement dates and specific requirements potentially in terms of process. So as those requirements commence, that's the date at which you may consider them, or you may not be able to consider them, and it may be for council separately to commence a different process in respect of those new requirements. So it's a little bit hard to follow and map your way through those changes, but we'll be here to assist you with those. But just to reiterate that at the moment you apply the RMA and the national direction as it is. The statutory assessment summary is there in the next section. I've then briefly addressed at paragraph 20 the submissions that were notified in a summary quite late in the piece, and that those were the broad submissions. So the comment there is council considered those submissions had sufficient clarity to require a decision to be made by the panel on those submissions. And therefore provide scope for that submitter to give submissions and evidence at the relevant hearings as they may wish to do or not wish to do. And that particularly plays out where the submission in support of the plan as notified might then attract or be contradicted by an alternative submission from another party which seeks an amendment and then may require a response. But I believe you'll probably have some questions about that, and there's certainly documents that have been filed by Hokonui Runanga which address this issue in detail as well. So perhaps we can save that for discussion in questions next. The next section talks about submissions which are not necessarily on the plan or aren't quite right, so that gives you some assistance there in terms of treating those submissions. And then finally, I just note the panel's ability to make minor changes, which of course with a document like this does come up quite a lot. So that's for those typos or those little changes which are required for consistency when you do make an amendment. And Mr. Hill has addressed some of those in his report. So did you have any questions on those topics for me?
Yes, I have a question. Your point about changes to the RMA, or we consider submissions with the RMA as it stands today, and that can be adjusted when changes are made. I get the impression from what you said that is discretionary for the panel?
So I have addressed this in the paragraphs at 13, 14 and 15. So your discretion to apply any new policy has a strong boundary around it in terms of what has been sought in submissions. So you do have discretion to make changes in line with submissions, but outside the scope of those submissions, you would not be able to do that, and it would need to be commenced by a fresh process. So that lines up with the general expectation that the community needs to have seen what was notified in the draft plan and then seen any submissions, understood the potential scope of change from those submissions, and then made a decision to participate or not. So the hard ring fence around what your discretion is derived from the submissions, the scope of the submissions themselves. I would suggest, and I have noted it there, that the panel does have a bit of flexibility in terms of process to give notice that there's an issue that's arisen as a result perhaps of a new requirement in a national policy, to then re-engage with issues as the hearings proceed. So that is available for you, and your discretion in terms of process is broad.
Once again, so you're saying that as amendments made by the government to the RMA, that would kick off a new process, really?
And this is where we end up in a bit of conjecture, unfortunately, because the new process that might need to be kicked off might be directed in the national policy statement, or it might be a narrow amendment which can be dealt with within the scope of submissions. So this is why we really have to just apply it with what we've got today, and then look at the new document and make those calls. And we'll be here to assist you with interpreting the scope. The council will make submissions in terms of the scope of the changes required or the process that might be required. But I'm not saying it's easy, but I am saying there's a way to map it through But
And so an alternative further down the track, if this plan is adopted, would be a plan change, wouldn't it?
perhaps I didn't make myself clear. That was exactly what I was talking about. If the council, or there's something outside scope of submissions that this panel can't make decisions on, yes, very much so, then the council can decide to make a plan change, or sometimes it can be a variation, which then can potentially catch up with the district plan review. So yes, and that decision comes at council, from council.
Any questions from other panel members?
So with regard to your paragraph 20, so we have some, what I'd describe as general submissions that say the whole of the plan is supported except where subject to specific matters. And so your advice is that that gives them standing to appear and speak. From a process point of view, some submitters may be taken by surprise that those particular people that have done the general ones come along to a hearing and start speaking against what the more specific submitters have raised. Would it be appropriate, therefore, for the general submitters to actually go first in the hearing process so that the specific submitters actually have the opportunity of responding?
I wonder if that's a decision that could be made in respect of each topic, but my suggestion would be that Mr. Hill or his colleagues would be speaking on the form of the provisions as they were notified and any proposed amendments regardless. So if the submission was about the notified form, then I would anticipate they would be in support of that form of the provision. So perhaps hearing from someone responding to the notified version first might not be quite so logical in that situation. I would anticipate the evidence or position that would be put forward by those parties that made general submissions would be in support of the notified version.
But it also gives them the right, if I understand you correctly, to argue against changes sought by other submitters. So in that regard, I'm wondering if they should go before the other submitters rather than the general ones coming along later.
And I think that probably comes back to the point about dealing with it at the time of each hearing, because you will receive evidence from each party. So where there is a strong dispute about a particular provision, perhaps that is where you can make a decision procedurally about who you might want to hear from first. But you will invariably be hearing from the Section 42A report author, who will have engaged with a lot of that content as well first. So that would probably be where you would get a lot of direction from, and then that would map things out for all parties. So I wouldn't expect it to be a surprise where any parties with general submissions, because of the fact that evidence and any submissions need to be filed prior, and the 42A report author will also be engaging with the issues. Sorry, if I could just add as well, I do note, so for example, Transpowers made the general submission on the chapter they're interested in. They're seeking specific amendments to 1 or 3 provisions, but their submission in respect of the general chapter provides for them to do a little bit of shifting on the other provisions they haven't got specific changes to. And that's probably where a lot of those broad submissions will come into play, is where you've got that sort of positioning between the provisions which don't have specific submission points, but still give scope to make the jigsaw fit together well in seeking decisions from the panel.
Just so I'm fully understanding, so with the general ones, they can't then introduce new suggested changes that aren't dealt with in other submissions. So there is no scope to go beyond the changes sought overall.
And that's where you can come back to the direction or the summary we've provided you in terms of scope of submission. So it's really summarised in, sorry, if you could just give me 1 second. Paragraph 19, it's submitted the panel has broad scope to make amendments provided it is confident they are a logical consequence of the matters raised in the full range of submissions, such they would not prejudice a potential further submitter who had elected not to make a further submission. And I anticipate you will hear a lot of submissions from parties who are trying to fit together everyone's positions. So that movement in a provision is something which you are, you will see commonly, and I'm sure you're very used to fitting together all of those positions to draft a provision which takes a full account of everyone's views.
Kia ora, thank you for your submissions. They're lovely and clear. When I was reading your paragraph 10.2, and it's just the having regard to any management plans and strategies prepared under other legislation, within that ambit, presumably there's a relevancy element, and I jotted down, for example, conservation management strategies. That was something that seemed to me it was a strategy that would have local application prepared under conservation law, that would be sort of in that category. Do you have any other observations on what else we might pay attention to that could be relevant to our business? Yeah.
So, for example, in this for this hearing, Mr. Heal has referred to a lot of those relevant documents. I would submit that in terms of something like a conservation strategy, if the Department of Conservation had referred the panel and generally the community to a particular document as being relevant, then that might be your pointer for considering that document. I would not necessarily suggest that the panel needs to go out fishing for any other documents, or if there was a document that the panel was aware of, it considered was relevant, it would be helpful to ask submitters if that was relevant, or publicise that in a minute or such other method if it hadn't already been brought to the table by submitters.
Yep. And I had, in terms of, it's not specific to the advice that you've provided or the submission that you've made, but it's because of the questions that I'm going to ask Mr. Heal, one of which is around the language in the definitions, in my observation that some of the definitions have a combination of sort of clear language in an intro string and then a lot of explanatory text. So I thought I'd start with observations from a legal perspective around, the quality of definitions and their application and legal interpretation, and any observations you might have in that respect. I'll just add that when I'm looking at those definitions, I'm seeing that explanatory text potentially in italics as advice associated with the definition. So just kind of wondering if you've got any observations to make on that.
Thank you. So definitions, as you know well, are part of rules, and rules need to be clear and enforceable. So if there is a part of a rule or a provision of the plan which the panel considers is not sufficiently clear or enforceable, or it sees it in a different, as having a different, any text as having a different purpose, such as being an explanatory note, then that's for the panel to consider in terms of workability of the provisions. So I think probably it is a planning call in many respects, but perhaps if we can hear from Mr. Hill, and I'm happy to address, you know, in terms of a concrete example, what you, whether you, so first of all, your guiding light is whether you have scope to make those changes, but certainly in terms of drafting, just probably that clear and enforceable point is the one that I would, from a legal perspective, that is key.
Yep. And so you've hit on the other thing that has been happening for me as I've been going through particularly the definitions and thinking about this clarity and workability element, and how that corresponds with the advice that you've provided around scope and how far we can move. Yeah.
And I guess that's the dance for the panel, is to consider whether you do have scope. And if you don't have scope, there are tools available to seek to bring something within scope. So that might be looking to expand it, but you do want to take care with that. And I guess perhaps again with a concrete example, I would be able to review the submissions and including the specific submissions and factual context against this case law which I've summarised.
Yep.
So we could assist you with that by providing an interpretation in respect of a concrete example if that would assist. But I'd probably prefer not to speculate.
To a broad, yeah. So that's probably an indication that when I get to Mr. Hill, there will be quite a few that sit in this category, and we might be able to put some to bed pretty quickly, and then we might want to go, yeah. But I thought it's an important part of the conversation that, yeah, that I'll be wanting to have.
And if I could add as well, you know, a lot of that stuff plays out as well when you're considering the actual direction of the rules. So the definition inevitably can't be considered by itself. So it may be content that can be discussed further in later hearings as well, and then fitting it all together at the end, especially where definitions play out in different chapters, that can be particularly tricky.
Yeah, so I think my goal today is to maybe flag some of that stuff too, and some of it might get bumped to later hearings, but yeah.
If I could add, there may be some things that we need to deal with in a right of reply if you're wanting to know about detailed scope and those sorts of things.
Yeah.
So, for example, if you did signal those definitions, we could potentially provide a short summary indicating where they might be considered later, and that would then be public for all potentially interested parties, if that would assist.
Just sticking with definitions, I'm aware that there's several definitions where the defined word is not used in the plan at all. And so I'm just wondering whether under the schedule clause 16, whether we have the ability just to delete them because I guess their effect is nugatory.
Well, I know Mr. Hill addresses that, so I can help in terms of process, but shall we work through, certainly in terms of the one that Mr. Hill's addressed specifically in the 42A report, obviously that's clear and been made available to everyone, so unless it attracts any comments today, I wouldn't see it as being a concern.
I guess it's just a matter of, and we'll talk about it with Mr. Hill, whether it was within the scope of the submission or whether we should be using clause 16 as the mechanism.
Apologies, I think clause 16 would be appropriate for the ones that are in the 42A report. Is that the method you've proposed it be changed?
Yeah, that's correct, unless there's a specific submission requesting.
Please proceed, Mr. Hill.
Cool. Thank you. I've prepared some supplementary evidence that responds to the evidence we received, and some that we might not have heard yet. I'll just send these out. Oh. She's gone. Sorry. So I just thought I'd run you through this because obviously a lot of this evidence was filed 10 working days before the hearing. Some of it came in on Friday because they were short submissions. Some people have indicated that they would provide written evidence that we haven't received. So I just want to talk you through what I've done here. So on the first page, you'll see I've covered off the scope of the evidence, so what evidence I've received and what evidence I've reviewed. At paragraph 4 on the next page, I state that I haven't reviewed the evidence of Heritage New Zealand. They signalled they were going to send some in, but I don't think we've received anything there. Environment Southland are coming to speak, but they haven't tabled any evidence similar to Groundswell. And at paragraph 5, I've just indicated where in my 42A report, which paragraphs I've responded to their submissions, so that when they come in, you can see whether what they're talking about is within the scope, and also where I've responded to it in the hearing report. At paragraph 6, I've identified a number of errors throughout the plan. I'm sure you might have picked up some of those, but I thought I'd just run through those first, because there's things like paragraph numbering, so if we're going to be having a conversation about paragraphs, it's probably important to get that right. So on page 12, at paragraph 41, I list a number of errors, and I'll just talk you through those. So if you have a look at the 42A report, if we just go to paragraph 5, which is on page 8, you'll see there that I've said overall there were 201 submission points and 223 further submissions. That's not correct. Hopefully you didn't go looking for them. So this should say, this is in relation to hearing stream 1. We received 204 submission points, not submissions, and 56 further submission points. And if we move along at my, sorry.
Excuse me, can you just repeat?
Sure. So if you look at, if you've got the section 42A report here, and if you go to page 8, and if you look at paragraph 5, you'll say it says overall 200 submissions and 223 further submissions were received. So that should say 204 submission points. And 56 further submission points.
And 56 further submission points.
That's correct. And these are all summarised in Appendix B of the hearing report. So moving along to paragraph 98, which is on page 30 of the hearing report. It basically indicates that the panel can make recommendations to the council. I've checked the resolution. The panel has the power to make decisions. It's not recommendations back to the council. No, that's not what the resolution of the council.
I'll check that.
Okay.
Will you give me the reference to that?
Sure, so that's paragraph 98 on page 30. Yep. Now, Shelley's going to deal with that issue because there's a potential issue there.
Apologies, it's Mr. Hill's checked the council resolutions, but I need to check the RMA as my understanding of section 32A is slightly different. So if you wouldn't mind, I'll just double check the RMA and come back to you after lunch about that.
Thank you.
So if we move along to page 34, you'll see the paragraph numbering's gone a bit skew-if. And at the bottom of 34, there's two paragraph 115s. My suggestion is that you make the second one, say 115A. And you'll see that it then goes 116, then 120. I'm not proposing to change that numbering because at least it flows, but I am suggesting that above paragraph 120, we just put a heading in hearing stream 1 submission points, because that's what paragraph 120 onwards is about. So if we go over to similar issue on page 39, you'll see the numbering's been duplicated again. So we've got 144, 145, 146, 147, 148, and then over the page on page 40, we go back to 144, 145, 146, 147, 148. So I'm recommending that on page 40, all those numbers get an A after them so we can distinguish between those paragraphs. Okay. So on the new paragraph 145A, which is on page 40, under the word assessment, I just note that halfway down that paragraph I've used the wrong submission numbers. It says submission 137.008 and 137.001. They should say 138, not 137.
While you're on that page, I don't know if you picked up the next paragraph at 146A. You refer to submission number 68.0031. It's 68.001. Top line of paragraph 146A.
Yes.
And that may be a data entry issue because later in the report the same error is made.
Yes. Okay. Thank you. paragraph 185, which is on page 49. 185,182 should be 115,182.
Paragraph 185.
The second number, 185,182, should be 115,182. Similarly, on page, oh, sorry. Great. On page 66, paragraph 258. You'll see Ronald Crispin has been referenced at 60.042. It should be 60.044. Paragraph 257. Oh, so this is, oh, sorry, 275. At the end of that paragraph on page 69, I say it's noted that the multi-sports and showground areas are actually precincts rather than special purpose zones. So an amendment is proposed to correct this error. Well, actually, they're already identified as precincts in the plan, so there was no error there. So, and then the last one in paragraph 50 refers to...
I'm sorry, Matt,
Oh, yeah.
what's your suggestion there for that?
So you just cross out that last sentence of paragraph 275. So Appendix B, which is the big table of changes, recommendations. There's a rogue recommendation there, which is on page 93. Find that, you'll see this is in relation to submission 143023 from the Rural Ratepayers Group. It says in the right hand column awaiting recommendation. It should actually say accept, because that's accepting the definition of building from the National Planning Standards.
Can we just clarify, and that's a good example of the way you've used accept in part, reject in part, and in other cases you've got acknowledge, and in some cases you've got note. I guess I'm interested in the legal input as well. In terms of making decisions, do we have the scope? So the Act talks about accept and reject submissions, but as good practice, frequently where there's a neutral submission, we note it or acknowledge it. So is that still good practice? And then I'll lead on to the other part.
So a good example of that is on paragraph 166 on page 43. So this is where, for example, Wireless are seeking that the subdivision land development bylaw be integrated into the proposed plan. I'm indicating that there are parts of the bylaw that have been integrated into the proposed plan, which is why I'm accepting that in part with no changes rather than rejecting it.
And where I struggle with is they've asked for a change and you've done recommended that no change be made. So to me, you've actually rejected the submission. And it actually, the one that you just had in Appendix B is probably a better example, which is on page 93 of Appendix B, where the rural ratepayers have said retain as notified. And so you've accepted that. But there's other ones where you've accepted the submission that says retain as notified, but changes have been made to the definition. So where there's a neutral one, should we just be noting them rather than playing around with accept in part or reject in part?
I think if a change has been made off the back of another submission, let's say, and they are seeking that it be the same as notified, then I'm rejecting the one that is same as notified, because it won't be the same as notified.
Okay.
I'll be making a change off the back of another submission. I think part of the other issue is that a number of these submissions that I've accepted in part with no changes stems from the fact that a number of those submissions are very broad, and so it's a bit unclear exactly what they're asking for, and so I have accepted them in part but made no changes. An example of that might be paragraph 190, I think. So this is Federated Farmers on page 190, where they're saying things like the submission seeks common sense ideas, engagement with federated farmers, for example. I've indicated that we have engaged with landowners. That's not a change that needs to be made to the plan. So I've accepted what they're saying, but I haven't made any changes to the plan because a change in the plan isn't warranted in order to address that submission.
Right. Good perspective is...
So just my comment would be to observe that where accepts is to think of it in terms of scope. So where you accept something, it's because you've relied on that submission to give you scope to change it in the way that it's seeking. It may not be exactly how it's sought, because you might have 3 submissions on the same provision, and between those 3 submissions you're accepting different parts. I would suggest that while Mr. Heel is saying accept in part, that's probably to convey his analysis, but for you as a panel, you are accepting or rejecting. So you are able to make those final decisions in a slightly more definitive term, but keeping in mind the scope, because you are accepting something in reliance on them asking for it, because if they didn't ask for it, you wouldn't be able to make that change.
Very helpful, thank you.
Matt, excuse me, just before you
Sure.
move on, I got lost a little bit there. The wireless submission, there was some amendment or comment that you had there?
I think that was
Paragraph 166.
166. Oh, sure, yeah. So that was in relation to Commissioner Havel's question about, you'll see in the 3rd line down, or 2nd and 3rd line, it is noted that the relevant portions of the bylaw have been incorporated into the plan, so that this point is accepted in part, because they've asked for the whole bylaw to be incorporated into the plan. And I've said, well, some of it has been, therefore we've accepted their submission point in part. Okay.
Can I just butt in, apologies, just further to paragraph 98 of the section 42A report. So section 34A of the RMA says that the ability to approve a district plan is reserved to a full council only. So your final decisions are on the provisions, but the last step in terms of the Schedule 1 plan making process sits with council. So the legalese I'm worried about, and I'm sure Mr Hill wasn't worried about, it's probably 98 just needs to be amended to say the panel will preside over the hearings and will be making decisions on submissions, and then just strike out the recommendations part. Having said all of that though, I do note that designations are their own unique beast and have a particular process of their own, including an even more complex process where it's a council designation. So I have made a note to make sure that we do assist you with that in terms of process and submissions in advance of considering designations. And in terms of this particular point I'm making, I'll also include it in our reply.
Just while I've got you on page 13 of my evidence, you'll see in my hearing report I said I would give an update on further submissions. So these are the 3 submission points we were talking earlier from Hokinui, Rinanga, Transpower and McNab. So just to update you, we got no further submissions on those submission points that we re-advertised. And also, while I've got you here, in the hearing report, I also said I would give you an update on RMA reform. And just to bear in mind, this needs to be seen in light of earlier legal submissions. So you'll see at paragraph 53, I've given you some text from Ministry for Environment website where they've indicated the Resource Management Bill that's been released covers a number of matters, largely regional matters, so relating to freshwater national policy statement, etc. On page 14, you'll see I've underlined suspend for 3 years requirements under the National Policy Statement Indigenous Biodiversity for councils to identify new significant natural areas and include them in district plans, which is the main change that could potentially affect this process. But the key point I'm making here is that that bill is anticipated to be in place before the end of this year, and that the hearings relating to the biodiversity chapter of the plan will be heard after that, so you'll be able to consider whatever potentially comes out of that process subject to scope of submissions.
In the event that the bill is passed and it's apparent that what is in the notified copy of the plan will need to be altered and there is not a scope of submissions to do so, would it be appropriate for what process should follow rather than waiting for the hearing?
So potentially a variation could be promulgated. Having said that, I believe the submissions on that chapter are very broad. And so, for example, if the final bill says, we can only rely on the existing mapped SNAs, which there's 2 in the city instead of a lot more, I think that would be within scope of the submissions because they're seeking that only, there's some submissions seeking that only those 2 sites are identified. But this is all speculation because we haven't seen the that the bill hasn't been enacted yet. All I'm signalling is that because of the way we've staged the hearing process, if the bill is enacted when it's expected to be enacted, then we can address that at the time. So, if I just take you back to paragraph 15 of my evidence on page 3, so above that I've done a summary of my recommendations, which I'm not going to take you through. I'll take you through the substance, but paragraphs 10, 11, 12 and 13, for example, and 14 might be useful as a high-level guide for when submitters are speaking. I've, at Appendix 2 of my evidence, I have highlighted some recommended changes. So if you have a look at Appendix 2 on page 17, subject to reviewing the evidence, I've recommended that some further changes are made. And you'll see what I've done here is the red text are new recommendations as a result of reviewing the evidence. The black underlines and strike-throughs are what was recommended in the hearing report. Okay, so the red stuff's new, the black and white stuff is what I was recommending in the Section 42A report.
Excuse me, through you, Mr Chair. Matt, just for clarification, there's red writing and it's been struck out. That's in part 2, district-wide matters.
That's correct, yeah.
So that means it's red text are recommendations.
Those are my latest recommendations
Your
based
latest
on the
ones.
evidence that has been presented since I wrote the Section 42A report, or the hearing report. Okay, and I'll take you through those as we go through my evidence.
To avoid us having too many different copies of everything, can you please provide us with an updated full copy of Appendix 2 from your 42A report that includes these as well?
Yeah, if we can just make a note of that, and I'll circulate a copy of an updated Appendix A, I think it is. Yeah. Which
And then that can go on the website, so it's available for everyone to see as well.
Sure. So I should take you back to paragraph 9, which is on page 2. So what I've done in Appendix 1 is I've provided a synopsis of evidence that's been presented, and as you'll see, I've highlighted the word reverse sensitivity. That's because a number of those submitters have supported the 42A definition of reverse sensitivity in their evidence. And they've also reported the changes that I'd originally recommended to Urban Form and Development Objective 1. So that's really just highlighting that there's general support for those things. So coming back to paragraph 15, this is where I start going through the evidence received in detail, and I'm not going to read it out verbatim, but I'll just take you through some of the key points. So at paragraph 16, you'll see Federated Farmers agree with a range of definitions: waste, river, building, UFD 01 and UFD 11. At paragraph 17, this is where they're indicating that I've used the term lawfully established in Eco R1, but that I've italicised that, but it's not defined, so that's an error, in my opinion. And they've also highlighted that the terms dry abrasive blasting and wet abrasive blasting are in the definitions, but they haven't been used throughout the plan. So I'm recommending that those definitions be deleted. At paragraph 18, changes are also sought to the definition of reverse sensitivity to retain the word approved, but delete the bracketed terms. So if you have a look at Appendix A, just got to find the definitions. Yes. See, if we look at Appendix A on page 30, yeah. So you'll see the definition refers sensitivity there, and I've recommended the inclusion of the words approved whether by resource consent, certificate of compliance or designation, lawfully established existing or permitted activities, and lawfully established at the end of that definition. So Federated Farmers are saying you don't need the bracketed text, even though others have supported this for further clarification. I'm suggesting that those words should be retained, and the reasoning for that's explained in my paragraph 18, partly because I think it adds clarity, because approved could be approved by a bylaw, approved by the Building Act, etc. So I think having the bracketed terms, whether by resource consent, certificate of compliance or designation, helps with clarity. So that's what I'm suggesting there.
This was something that I had some questions around, and just hearing your answer then, is another way to do what you've just described, actually do what Feds are suggesting and have a definition for lawfully established, and that definition of lawfully established might scoop up resource consent, certificate of compliance, designation and existing use?
Yeah, I don't think they're asking for a definition of lawfully established. I think what they're saying is it hasn't been used in the plan.
Oh, sorry. No, I think I think my question, when I go back to my little set of questions, was probably, do we need a definition of lawfully established to address the issues being raised, actually? Yeah. Sorry, you're right about that.
I don't think there's scope to do that, so I think if you want to clarify what's meant by approved, then the way to do it is off the back of other submissions where they've asked for bracketed terms.
And if I could jump in on the lawfully established point, it almost, in the trickiest examples, it requires a moment-by-moment or fact-by-fact assessment. So the ability to define that's probably turns into a never-ending hole.
Right. Although if it was defined in the plan, that's what it would mean in the plan?
Well, it would also be difficult because it would be what it would mean in the plan, but then it wouldn't necessarily relate back to the legislation or other surrounding law. So, for example, I'm thinking of an existing use, without wanting to complicate things, because existing uses always do, but existing use requires a very property-specific or activity-specific assessment to know what is lawfully established, and sometimes it can need to go to a court to determine that. So I would suggest that lawfully established is a battle that's reserved in a specific context.
So hearing that legal assessment, what does that now mean when we do have the term lawfully established utilised? So it becomes a little bit circular, and that we do definitely also have a definition in there for existing use. So thinking about, clarity and ease, I guess, and consistency.
Yeah. So I think the reason we've used lawfully established, the reason we've used approved, is because those are two different things. So you can have something approved by way of resource consent, for example, but something can have existing use rights because it's been there for 100 years and the use hasn't changed. And so that's why there's a distinction in the definition.
And I think that's what I'm getting at, because you do have a definition of existing use included, and that maybe we, if you're keeping the bracketed text associated with the word approved, and you utilise the definition that's already included in the plan for existing use rights, does that cover everything that you want to cover without bringing in the term lawfully established to complicate matters with it being undefined?
I would suggest that lawfully established is important as a catch-all because it's flexible enough for the future to be able to accommodate any future things that we don't know in terms of what a lawful requirement. I would also suggest that in the main, what's lawfully established is probably going to be pretty obvious on the face of it. There are going to be tricky examples which, if you do include a definition of lawfully established, it's going to make it much harder. But in the main, lawfully established will be relatively obvious when people really delve into, say, a property file and find that there isn't, this hasn't been happening there before, for example. So I would suggest that in the main, lawfully established will be relatively straightforward to apply just on those two words without a definition. But then if you were to define lawfully established, you're going to add too much complication and it will remove the flexibility you need for future, to accommodate future changes to the legislation.
So then thinking about the fact that we do have the definition of existing use rights, and then looking at the fact that the phrase in this says lawfully established existing, which is, I think, where Federated Farms were coming from, then are we better to separate, just on the advice we've just heard, the term lawfully established and put where you've got existing reference to existing use rights, so that we're being really clear, because what I've just heard is the bracketed text will tell you what approved means. Existing is referring in part to existing use rights, but when you use the term lawfully established, you're providing a bigger net, so that these three terms are each offering something in terms of our understanding.
I think that I can't see a definition of existing use in the plan. I'm just looking at the notified version here.
Got myself tangled up then, haven't I? Sorry, no, it's just the reliance
definition
on,
of
in the
reverse
RMA,
sensitivity.
it's just the
I think.
reliance
Yeah.
of existing use under the RMA.
Yes.
Yep.
Yeah.
I think as well you're getting into that those grey areas where you have, say, a notified plan, or you have provisions with legal effect that and you also have some curly little provisions in there around when provisions take effect as well. So probably that's captured by lawfully established to when we're digging into those consent applications, which are captured by the 87B
Yeah,
and
right.
all those tricky little provisions and things.
Nuances.
Yeah, so I'm wondering whether lawfully established captures that.
And
Then
the
you've got
word
existing,
Yeah.
and then you've got permitted. I actually think as well the bracketed text needs to not be exclusive to those three items because, again, it doesn't accommodate for that potential future change, or it might be an approval under a bylaw, as Mr. Hill observed. So.
Has that answered that question for now?
Yeah, it does sound like something that you could come back on potentially and write a reply.
No problem.
Thanks.
Matt, just want a bit more clarity. You're saying existing use is not, there's not a definition of existing use in the plan, save where it's considered broadly under reverse sensitivity. Should there be a definition of existing use?
The existing use is explained in the Resource Management Act. I think it's section 10A. So there's not a need for it to be in the district plan, and I think it's, as we heard from legal submissions, it's complicated. So to include a definition would be difficult.
I guess we Federated Farmers, and I'm making an assumption here, would be considering their agricultural activity, which is in general a permitted activity and an existing activity. Is there any disadvantage to have those bracketed sections? Look, I guess to somebody to that activity, I can't see that there is, but you.
I don't think there is. I think it's clarifying what we mean by approved. It may be that there are other methods of approval, so potentially that should say including by resource consents through to compliance or designation, because then that means you can think potentially factor in other types of approvals.
That whole discussion came up. I guess it's dealt with in your report at paragraph 259 on page 66, where you've set out your recommendation. I'll just wait for everyone to get to it. So that's paragraph 259 on page 66. And I tried summarising what you've said there as follows. Reverse sensitivity, the potential for activity 1 to be compromised on the third line by activity 2, which may be sensitive to the effects generated by activity 1. And it seems very convoluted to arrive at that point, particularly with the way that which is used in the middle line. Because I was left wondering now, which activity are you talking about in that line, 1 or 2? It'd just be very nice if it could just be made a little bit clearer.
Okay, we'll try and address that and write a reply.
Yep.
Is this something we're looking what other plans have done might help you?
We have looked at other plans, and that's how we arrived here.
Yep.
And we've also, as I said, there's a number of submissions from other parties that have agreed with this approach because they believe it provides more clarity. So,
Yep.
Yeah, I guess submitters need to be aware that just because there is a recommendation of a certain type in your report, either rejecting or accepting, the panel itself may not accept your recommendation.
correct. Okay, so paragraph 19, you'll see Federated Farmers are still seeking changes to UFD 010 to protect the contribution primary production and rural industries activities make to the economic and social well-being of the district. I still have concerns about how protection could be interpreted when effects of primary production and rural industry activities need to be balanced with other matters such as amenity, critical resources, and I've outlined this in paragraph 354 of my report. So I therefore recommend altering UFD 010 to include recognised and provide for rather than recognised and protected. In my view, that better aligns with the purpose of the RMA, which is to provide for social and economic well-being while avoiding, remedying and mitigating adverse effects and preserving or protecting a range of Section 6 matters, such as natural, cultural and heritage features, and having particular regard to a wider range of Section 7 matters, such as amenity values. So, in my view, that needs to be balanced. And this also aligns with the general policy and rule framework of the General Rural Zone, which seeks to enable primary production and rural industry while preserving or recognising a number of amenity and natural features. So rather than protecting the contribution, I'm suggesting that it be recognised and provided for, and when this is read in balance with the other objectives, that's put in the context of needing to also protect a range of other matters such as heritage and cultural values. So that's.
So on that,
yes.
that language recognised and provide for is very specific to Section 6.
Mm-hmm.
And so when I see particular activities being lifted up and given that language and put on a par with those Section 6 matters, I guess looking to be really clear about where the direction is in the statutory context to use that language for anything other than Section 6 matters?
I think the basically, if you look at the focus of the rural zone, because this objective is in guiding what plays out in the rural zone to a degree. We have generally provided for primary production and rural industry activities in the rural zone.
So when I come down to your paragraph 21 of your summary statement where you are using the word enable, that is a term that is often appears in objectives and policies that are seeking to, support particular activities to occur in a particular place in a particular way. So enable seems to me to be what it is that you're trying to achieve, and the language of recognise and provide for, I've got to say, causes me quite a bit of concern because, as you know, these objectives have to be read together, and they'd be read together with objectives for Section 6 matters, and then these activities would be put on a par. And some of what's recognised and provided for in Section 6 does come with some protective wording, some, brings in avoid type language when you're thinking about objectives and policies. So I'm just wondering if you want to have another think about what it is, because I read your paragraph 21 and it looks to me that the purpose is to be enabling, and that being enabling would then follow cascade down through to your rule classifications and things like that. So is that another way to cut this that might be a bit more in line with part two?
I think that's something we can come back to in a right of reply. I guess for me, there's a distinction between enabled and provide for. We've relied on you'll see I've referenced the Wellington City drafting guide. That makes a distinction between provide for, which spans from permitted to restricted discretionary activities, and enabled, which typically means permitted. So in the rules, when you get to the rules, these activities they're not permitted necessarily. Some things require a consent pathway, but they're a low level consent. That's the only, we can certainly take that away and have a think about it, but that's part of the rationale for using the word provide for, and I acknowledge that might rub up against Section 6 matters, but it also needs to be seen in the context of all of the objectives in UFD, in the Urban Form and Development chapter. So UFD 01 puts some riders around what things need to be protected across the district. So yeah, we certainly take that on board and consider it in rebuttal. But I just wanted to outline that was the thinking behind it.
That was the thinking, yeah. And so when you were saying about you'd had a look at the Wellington example, have you got a paragraph reference in your Section 42A to draw my attention to?
Let's see. So there's certainly discussion about the Wellington Design Guide on page, not design guide, drafting guide on page 45, paragraph 173, which refers to it, but in a slightly different context. I think you'll see when I get through my evidence, I've also talked about a structured analysis. And in my hearing report, there's a table attached which has activities that should be enabled, managed and avoided, and that has informed the approach we've taken to the objectives, policies and rule structure, so that there's a clear line of sight between, if we're saying an objective avoid, then we land on a non-complying activity and vice versa, for example. And if we're saying enable, it's more likely to be permitted. And if we're saying provide for, it would range from permitted to restricted discretionary.
Yeah, and so it's, in that Appendix F, which I did find really helpful, and it's really good to have that clarity around the thinking and the logic, really helpful. But in that table, recognise and provide for isn't there. Yeah.
So there's a table in the Wellington guide that articulates what those terms refer to in terms of consent thresholds. So I think that might be useful, and I've got a copy of it, which I can pick out the relevant page and circulate that if that would be useful.
And presumably some of that will be coming from Part 2 and National Direction attached to Part 2 matters.
That's correct, yeah. So there are terms like protect, avoid, etc., which typically relate to Part 2 matters.
Yeah.
So
Not on that point.
I'm sorry, I'm going to make your task a little bit more difficult. Taking back to your summary in paragraph 19, where the Feds would like the word protect, which you feel is too strong, and you're considering other wording of rather to recognise and provide, and there's been a comment that might not be consistent with section 6 and a little bit too strong. I still think if we put it in the context of wider planning issues, we've got very strong language for some environmental imperatives, maybe some are recent. Why should we not afford significant protection for what is our major activity in this district? So I do want to see, so you'll have to come up with some, we would appreciate your, I would appreciate some strength behind the definition or that Feds are hoping for, not necessarily protect, but I do want to see. So I'll lay that challenge before you. Thank you.
I think it'll also be useful to hear from they're coming in today, so they haven't seen these recommendations because I've only just seen their evidence, so it might be useful to get their view on that, but I think the word protect would rub up even more against section 6 than provide for, because section 6 is about protecting particular things like biodiversity, landscape, heritage, etc. I hear what you're saying, and what I've tried to do is provide for rural activities and primary production within the context of those other matters.
I guess what I'm saying is I'm actually quite comfortable with recognise and provide.
Right.
So I agree with you on that.
Great.
Certainly want to see something of a certain strength.
I'm just wondering procedurally that in case Federated Farmers happen to be watching what we're talking about, is there a copy of your statement this morning that can go up online ASAP, so it's available?
I've certainly emailed it to the staff. I assume staff could put it online, potentially. It would have been this morning to ask for copies. Sure. I've also provided extra copies here if people want to get access to it. So I think that's largely dealt with my changes in relation to Federated Farmers. So moving along to Greenbrier, which is covered at paragraph 22. Just acknowledging that Greenbrier provided a synopsis of relevant national and regional policy relating to mineral and aggregate extraction, which highlights the need to recognise that some activities have locational constraints or functional and technical needs to locate in particular environments. Greenbrier accepts the changes that I've recommended in the 42A report relating to the Urban Form and Development Overview, UFD 010 and UFD 011, which recognises the need to protect highly productive land and other rural resources. Okay. Paragraph 23. However, they're seeking changes to UFD 01 and a new UFD 12 to provide for activities that are reliant on locational constrained resources or with functional or operational needs that dictate their location. And what I've said in my hearing report is that UFD 01 already provides for productivity and economic growth in Clause 4. So if you look at Appendix 1 of the Appendix A of the hearing report.
And just while people are turning to it, I'm just wondering as a panel, when we just get clarification on what Matt is talking about here, and if we've got any feedback, I guess, in terms of the recommendation, we actually wait for Greenbrier to be here and have the discussion both with Mr Hill and Greenbrier and other submitters at the same time. Might be probably the more appropriate way of dealing with it, rather than discussing any concerns you might have about particular recommendations.
So you just want me to run through a summary and then leave the discussion till when the submitters arrive?
I think that is the fairest approach, so the submitters are aware of the discussion that we're having with you.
One option might be for Mr Hill to speak at the outset, could use up time, that's all, but at the outset of the relevant submitter's presentation, just to summarise his comments and response, and then hand straight over. What do you think of that?
I think, if it's easier for everyone, we could give them a copy. I could talk through the relevant bit at the start of their submission period, if that's useful.
So I will definitely have questions that I'll want to hear your opinion from, and I'll want to hear the submitter's opinion from. So it's just knowing that that can occur, whether it happens now or as part of right of reply conversation, or but I've got, well, probably not as part of right of reply, but because the questions, I've got some questions, for instance, for Ms Justice, and the same questions to put to you to see where each of you are sitting in relation. Yeah.
It may be a time question. Procedurally, you could put the questions to Mr Hill now, hear those answers, put the same questions to Ms Justice later on, hear those questions, and then you would have satisfied your process. But the question for the panel is to consider whether it would prefer for that to run concurrently, so that Greenbrier is in the room, for example, using that one, and just noting that they have half an hour. So yeah, it's hard to know. It's like putting your finger on something.
I think it's clear we are not going to finish before 11:30 in questioning of Mr Hill, and therefore it's probably, we may catch up time later with the individual submitters. And I think, to me, I'm in the same position as Commissioner Bartlett, that I've got questions, the same question to put to both, and I think they both should hear each other's response.
Perhaps what I could do then is take you right back to the summary of this rather than going through the detail, which will keep us on track. You can review it, and then we can have a further conversation when the submitters are in the room, if that works. Right. So if you go back to paragraph 10 on page 3, I've already covered federated farmers at paragraph 10. Paragraph 11, this is just an overview. I recommend changes to plan structure text and the UFD overview to clarify the relationship between strategic objectives and other objectives and policies across the plan. So if we go to, maybe a quicker way to do this is to go to Appendix 2, where I've highlighted those changes. So you'll see on page 17, this is a part of the plan that explains the plan structure, and what I've suggested is that we remove the generic comments around it's intended that all other objectives and policies in the district plan are to be read and achieved in a manner consistent with strategic objectives, because this is providing a high-level overview. And I've accepted that generally it would be useful to have something in the urban form and development overview, and I think that should be more specific. And that's at the top of page 18, where it's outlining that these strategic objectives should provide direction for more detailed provisions that follow, and that for the purpose of district plan implementation, so that might be a resource consent, and notices of requirement, strategic objectives provide guidance for related objectives and policies in other chapters, and that the strategic objectives are to be considered together with no hierarchy existing between them. And I've explained the rationale for that in the detailed evidence relating to Transpower. So then just going back to page 3, I'm just signalling that changes to Urban Form and Development 01 and 08 acknowledge the role of critical infrastructure in the national grid to improve reference to reverse sensitivity effects in order to enhance alignment with national direction. So if we go to UFD 01 on page 18, you'll see 515B talks about providing the transition away from fossil fuels through increased use and development of renewable resources and the associated national grid. So that's on the basis that the national grid might need to be updated to upgraded to provide for development of renewable resources. And you'll see at UFD 08 that I've also indicated that critical infrastructure should be recognised and provided for, bearing in mind the conversation that we had earlier about the use of those words. So that's the approach there. I'll also, just so you're aware, if you don't want those objectives to be amended, I've also provided an alternative which does have a freestanding objective on page 10, paragraph 32. And here you'll see if you are minded to go in that direction rather than adapting the existing objectives, I've framed that around managing adverse effects on sensitive activities and sensitive environments, because the relevant national policy statement creates that balance, and I don't think the version that has been recommended in evidence has that balance. And that's kind of reflecting the conversation we were having earlier today about Section 6 matters.
And I just observed something in the way that you've structured this potential one associated with your para 32, where it's leading out with provide for, in the way that you've balanced inside is sitting a bit
Better?
more comfortably.
Yes.
Yeah. And that's based on understanding why you're placing emphasis on the word provide. Yeah.
Sure.
So I will go and have a look at what you've directed us to.
Great. So that was Transpower. Greenbrier. So I'm not suggesting changes to Urban Form and Development 01 or a new objective to provide for activities that are locationally constrained or with operational or functional location needs, as existing objectives already provide for existing primary production activities to continue to operate, and for a zone-specific solution to be considered in the future. So I think Greenbrier's concern was that not having a specific objective might hamstring their ability to have a specific special purpose zone for their site. What I'm saying is I don't agree. I think the objectives as they stand already provide for those activities in the rural environment. So that's what I'm talking about in relation to Greenbrier. And sorry, I just need to check something. So just to clarify, I might go through the detail of New Zealand Defence Force because as I understand it, they're not attending, so we won't have that to and fro kind of questioning, if you like.
Because they weren't turning up to the hearing, I was looking to explore a bit more your rationale
That's me.
there, so whether we do it now or later.
We're suggesting to do it now if we've got time because it's not subject to the need for the same questions to be asked of both parties because Defence Force isn't attending perhaps.
Yeah, so in terms of the tabled evidence from Defence Force, and I see that you've obviously looked at it, and at your para 13 in your summary you're still happy with where you landed. I noticed they were making some points around attaching non-complying statuses, again probably to do with the conversation we've just had around language leading you through to activity status, and they were making the point that non-complying is often associated with avoid and protect type situations, and that they thought innominate types of activities were being captured, and that the RMA treats those differently and treats them as discretionary. So when you've thought about that, would you agree with that, would be my first question, with that basic analysis?
So I've covered this at paragraph 35 to 38 in more detail.
Yep.
And you know, I acknowledge that it's common practice to have a catch-all, a default non-compliant, and this is NZDF's position that a default non-complying activity status is considered unduly onerous. Take it that's what you're getting at, and assumes an activity not specifically identified is likely to be inappropriate in the zone. But the way we've built the plan is different to other plans. So you've got the, you know, the table that you were talking about, enable, manage, avoid, and the catch-all captures activities that we don't want or we want to avoid in those zones. So, for example, if you look at the general residential zone, the default's a non-complying activity via general rural, residential zone rule 15, it's non-complying. But that aligns with the objective and policy direction. So, for example, GRZ03 and policy P9 effectively seek to avoid certain activities. And so in that chapter, for example, we haven't listed all the activities and said industrial activities are a non-complying activity in the residential zone. We haven't listed it because we've got a catch-all that says that. So if it's not listed, an industrial activity would be non-complying in the residential zone, which aligns with the objective and policy direction. Some plans go through and have an extensive list of activities, and they clearly articulate what's non-compliant, what's discretionary, etc. So I think Ms Davies has referenced the Auckland Unitary Plan, which she provides a guidance note from the hearing panel there, or reference to it. But when you look at the Unitary Plan, and I've got a copy here, for example, in the industrial zone, their default is non-compliant. And I looked at all the other zones, and that's also non-compliant.
If I can just help here, while we need to look at their submission in the wider context, I noted that temporary military training activities excuse me, are permitted as a temporary activity in the plan.
Correct.
Subject to standards, and if they don't meet the standards, they're restricted discretionary.
That's correct.
Therefore, in relation to temporary military training, they're provided for in the plan,
Yes.
at worst as a restricted discretionary activity.
Yes.
But their submission is general, so
Yes.
we have to deal with the general issue as well. So I just wanted to, and I guess if they were here, the question I put to them is, your activities are provided for, so is it that you haven't looked at the other provisions in the plan, or are you still concerned over the whole principle?
Yeah, I think, I guess the other thing to note is that we haven't had the hearings on the zone provisions yet, and so when you get to that, you'll have the ability to test what the consent settings are for different activities. And so whilst we're having this principled discussion at the moment, you'll be able to get into the detail and make sure that's appropriate at the zone level. So my recommendation at the moment is that you keep it as it is, but that might change once you've got to the zone level and gone, actually, we think we should be enabling more in this zone, or hey, maybe we need to make it clear that these things we don't want in this zone have a specific non-complying activity reference next to it, rather than relying on a default. So I think my position at the moment is a bit of a starter for 10. It might evolve as you get through the hearing process, and I think that's why we've done that structural analysis to try and align the strategic objectives as best we can with what's happening in the zone chapters and the citywide chapters. So as the hearing evolves, we might need to go back and revisit the urban form and development chapter.
I think that's a sensible approach, because we'll probably have to go back anyway if we get too definitive and delete or add.
That's correct. So that's largely, at paragraph 39, I go through Hamish Ware's evidence, which covers, it's largely, we've already talked about the default settings, I don't need to cover that. Financial and development contributions sit outside the plan, and that's clear. So forestry, I'm indicating that, in my view, that's already addressed by the NES commercial forestry and the protection that we provide in the Indigenous biodiversity and outstanding natural landscape chapters in that space. And then there's the engineering specifications, which we have included largely what's in the bylaw relating to earthworks and stormwater. We brought those into the plan because there's been some issues with implementation. An example might be earthworks. The sediment and erosion control provisions sit in the bylaw. The rules sit in the plan. And so we've had an issue in the past where consents have been issued with no conditions because they're relying on the bylaw, but nobody's enforcing the bylaw. And so there's a practical reason why we've done that for those topics. So that's probably covered everything I need to cover. I'm happy to take any detailed questions or leave it till later.
So can I suggest to the panel, since it's 11:30, we take a break here. We do have a number of questions for Mr Hill in terms of what's in his report. Given we've got submitters present, I think that it's appropriate that we hear from them rather than them sit around all day while we ask the other questions. Just noting that we'll come back to Mr Hill, I think, with your agreement at another time, even if it is tomorrow morning.
Yes, we'll have a short break.
Thank you.
Yep, we'll kick off again at 11:45. Right, we'll reconvene and welcome our next submitters and ask you to introduce yourselves. Yes, would you introduce yourselves? Thank you.
Kia ora koutou katoa, kia anu te biki e koutou, ko John Sutherland, tōku ingoa, environmental planner employed at Transpower. I'm accompanied by Ms Ainsley McLeod here on my right. And thank you, Chair and panel, for the opportunity for presenting today.
I just have a question for the other panel members. Does anybody consider they have any conflicts with this submission?
Thank you very much. Just acknowledging firstly that we've received the supplementary evidence of Mr Hill, so thank you for that. Transpower will be involved in subsequent hearings to talk to other chapters in a more detailed way. This strategic objectives chapter is a chance for us to introduce Transpower and set the scene for future hearings, and where we will come back and talk to you again. What I thought would be useful for the panel is just to run through some of the key points of my evidence statement, and then I'll hand over to Ms McLeod to talk through some of the Section 42A recommendations and now the supplementary evidence which were quickly reviewed, and then we can answer any questions or whatever works for the panel. Does that sound right? So Transpower is both the owner and operator of New Zealand's national grid, which makes up around 11,000 kilometres of transmission lines, over 170 substations and 300 telecommunication sites that are all linked together to form an integrated network located all throughout New Zealand, as far north as Kaikoui in the North Island and as far south as Bluff in the South Island. As system owner, Transpower's role is to ensure that sufficient investment is put into the grid to maintain, upgrade and develop it, such that power can be carried from generators to Transpower's customers. And that can include large direct connect industry or lines distribution companies. As system operator, Transpower operates the electricity market and carefully balances supply and demand using information it receives in real time. And this is to ensure that power can flow through the system at all times. It's worth noting that Transpower does not generate electricity and it has no distribution functions. It's that centrepiece of the system that carries bulk electricity supply from points of generation to where it is used. And in many cases, where electricity is used can be a great distance away from where that electricity is generated. In the Gore district, there are 8 overhead high voltage transmission lines, 4 of which are 220,000 volts or kilovolts, and the other 4 are 110 kV. There are also 2 substations located in the district. And in terms of project work happening in Gore district, there's nothing to note there in terms of upgrades or major works. And that's not to say that there won't be anything during the life of this district plan version. There will be some routine Transpower maintenance activities particularly on its lines assets, foundation refurbishment, tower replacements with poles, vegetation clearance and trimming, those sorts of things, just to give you a flavour of the nature of that maintenance work. Peak demand within Gore district is predicted to nearly double, so over the next 15 years, from 41 megawatts in 2023 to 77 in 2048. And this is primarily driven by the decarbonising and electrification of local industry, which Transpower is seeing an uptick in, and we'll see that continue. In a more strategic sense, New Zealand's electrification direction is determined by the Climate Change Response Act 2019, which sets domestic policy around carbon zero future. Transpower has done extensive work in this space, looking at what a carbon zero electricity system looks like, and that includes what sort of load growth demands can be anticipated and what role the national grid would play in a future electricity system to achieve those aspirations. Load demand nationwide is predicted to increase by 68% by 2050. And what that means for Transpower is that continued investment and enhancement of its existing asset base and the development of new infrastructure will be required, and particularly to connect to new generation sources. Transpower's development and investment strategy is centred around investing in its existing asset base and retaining its environmental footprint for as long as possible before investing in new build. To meet that 68% predicted load growth, the regulatory settings that Transpower operates in, which includes workable and effective district plans, will need to be such that Transpower is enabled to upgrade and develop the grid efficiently to increase its capacity and to introduce new infrastructure to new source of generation. The national grid operates in an open electricity market, which means that Transpower can't dictate where generation sources will be located, but it is required to enable their connection to the system. And Transpower cannot foresee where new future development will be. The location of their sources can dictate and constrain where Transpower's future infrastructure would be located. And just one final point I'll make is that as the grid is positioned all over the country, Transpower takes an active role in local authority plan making nationwide to primarily ensure that the national policy statement on electricity transmission is given effect to. This national policy statement recognises the national significance of the national grid. It also protects the grid against inappropriate subdivision and land use and activities. It also ensures that a consistent approach across the country is taken to ensure that the grid is enabled and can be developed in the future. So that's probably a good segue for me to hand over to Ms. McLeod. Thank you.
Yeah, I'm happy to wait till after.
Your paragraph 5.7 includes the assumption that the Tiwai smelter will be retired at the end of 2034, although subject to Commerce Commission, is it, or the Electricity Commission, the agreement that's been reached with the power company. Do you want to revise your paragraph 5.7 at all? And I guess the other point moving on is that with the agreement being in place, with a proposal for a major wind farm south of Gore, is your assumption in terms of the impact of your activities likely to change as well?
So with the Tiwai Point smelter closing, that is an interesting question. We don't have updated numbers to share. I suppose what I can provide from my expertise as a planner is that this reinforces the need to have enabling provisions so Transpower is able to react. We don't know when these decisions may come up again and change how load is treated and how it needs to react. So we need to be able to work in an environment where we can react quickly should we need to and make based on these decisions that come out.
And I guess for the benefit of other panel members, I'm aware that every several years you write to the council saying, let us know what developments are potential in the next few years so we can help our planning.
Thank you. I did have a prepared speaking notes, but I think we've moved on quite a lot since I wrote them this morning. So first I'd probably just like to acknowledge that you will hear from us again, and where John finished saying it, Transpower's position is very much around giving effect to the National Policy Statement on Electricity Transmission. So my evidence that you'll hear over the course of these hearings will be what the district plan needs to do to respond to that national policy statement and recognise the benefits of the national grid. Sometimes you'll hear from me that there needs to be a bespoke national grid specific response, and there'll be other times where I'll say something that's more generic, perhaps relating to critical infrastructure more generally, will do the job, if you like. So my evidence before you over the course of these hearings will be very much guiding you, hopefully, around how to give effect to the national policy statement in the plan. I think really where I should go this morning, so I don't waste too much of your time, is to work through Appendix 2 and the supplementary evidence that we've received this morning. I can respond to that verbally now, and if it's helpful to you, provide a written response after we leave today. So if we turn to Appendix 2, the first part is related to the guidance about how the strategic objectives work in the context of the plan. My evidence obviously had some concerns that it wasn't clear whether there was a hierarchy or not, and whether the strategic objectives could have the effect of trumping more specific objectives elsewhere in the plan. You now have evidence before you suggesting an amendment that is akin or very, very similar to the approach taken by the Environment Court in Queenstown, and I would support those amendments as presented to you in Appendix 2 to the supplementary evidence.
Just for clarification, so you're talking about the addition on the top of page 18?
Yes, and also the deletion in the box in page 17. So in terms of the next amendment, that is Objective UFD, Objective 1, Clause 5B, I support the addition of reference to the national grid, but I'm concerned about the use of the term associated. I don't think it's necessary, and the reason I say that is because the national grid plays one role in picking up the power, if you like, from renewable electricity generation, but it also plays another role in supplying renewable electricity to industry or industries and things like that that are decarbonising. So if a major industry in the district were to reduce their use of fossil fuels, they would replace that with electricity, and it may be that the national grid would be the provider of that. So associated would sort of only connect it to renewable resources as opposed to that other role that the national grid might play. So to be clear, I support the deletion of associated from that red text in Clause 5. I support the amendments in Clause 6 as well, and I'm comfortable with the provide for on the basis that Policy 2 of the National Policy Statement for Electricity Transmission states, in achieving the purpose of the Act, decision makers must recognise and provide for the effective operation, maintenance, upgrading and development. So the use, I know you've had a discussion this morning about recognise and provide. It's something that I would support in the context of the national grid, because that's what the National Policy Statement for Electricity Transmission says. Turning to Policy UFD Objective 8, I support the addition of critical infrastructure, but I'm concerned that the policy is confined to operation only. And again, that's because the objective of the National Policy Statement refers to recognising the national significance of the electricity transmission network by facilitating the operation, maintenance and upgrading of the existing network and the establishment of new. So, and again, Policy 2 talks about recognising and providing for the effective operation, maintenance, upgrading and development. So to confine UFD 08 to operation only, insofar as it relates to the national grid, wouldn't give effect to the National Policy Statement for electricity transmission. From my perspective, there would need to be an amendment following the word operate to add those further words. If that, subject to those amendments to the policy, Objective 1 and Objective 8, and subject to there being no hierarchy within the district plan, I'm of a view that the necessity for a further objective to address critical infrastructure is somewhat, well, significantly tempered compared to the position taken in my evidence. But that's also probably caveated by where we get to in future hearings in energy and infrastructure. But at this stage, if Objective 8 were to refer to maintenance, upgrading and development, and the other amendments to Objective 1 and ensuring there's no hierarchy and provisions, from my perspective, I could live without another objective related to infrastructure. And we can deal with the details about enabling, providing, managing effects of, managing effects on in the context of the energy and infrastructure chapter. That said, if you're of a mind to adopt a standalone objective for infrastructure, I think the solution is probably somewhere between what's been presented to you in the summary, in the supplementary evidence, and what's in my evidence. And the reason for that is, my view is the drafting provided on page 10 of the supplementary evidence is expressed as more as a policy as opposed to an outcome and objective. I'm concerned that it doesn't enable operation, maintenance and minor upgrading. It puts the effects management tests on those activities where the direction in the National Policy Statement for electricity transmission is must enable. So I think there's a gap there. I'm also concerned that in clause 2 of that proposed objective, it refers to avoiding reverse sensitivity effects only, whereas the concern in policy 10 of the National Policy Statement for electricity transmission is direct effects as well. By that I mean an activity can have a direct impact on the national grid. For instance, earthworks or conductive material close to the national grid can affect the national grid, or trees growing too close, that kind of thing. So clause 2 of the proposed objective wouldn't give effect to policy 10 of the National Policy Statement and doesn't address effects on the national grid. So I also have a concern that clause 1 might be too narrow, in that the national grid could have effects on activities that aren't sensitive activities or sensitive environments, and it may be that that clause ought to be broadened to enable responses to effects on other things as well.
Okay, can you just take a breath while I catch up?
Sure,
please?
sorry.
Through you, Mr. Chair, can I just ask a question while we're catching up, please?
Yes, please do.
You say to change the wording in UFD 08 after operate. Is that, did you want upgrade and develop?
Operate, maintain, upgrade and develop.
Operate, upgrade and develop.
Maintain, upgrade and develop, yep, thank you.
So if we have an objective that says able to upgrade, is the implication of that at a rule level to be permitted?
I'm suggesting minor upgrading be the enabled component rather than upgrading more generally. So in my evidence version, I've just got upgrading there, but if the intention is to use this objective to drive a permitted activity, then consistent with Policy 5 of the National Policy Statement on Electricity Transmission, it would be enable the operation, maintenance and minor upgrading.
So are you now advocating that that's the wording you'd like to see?
Yes,
Yes, so maintenance and minor upgrading.
yes.
And so separating out development.
Yes.
Yep.
It would typically be my evidence that minor upgrading should be a permitted activity, and more substantial upgrades, which the terminology in the National Policy Statement talks about substantial upgrades, would trigger the need for a resource consent.
And so at the objective level, we might be distinguishing between
Yes,
substantial upgrade and development and
yes, you could use substantial upgrade
operation
as well,
maintenance.
but I think development is broad enough to pick up
Yep.
anything that's not operation, maintenance and minor upgrading, yes.
I'm noting that your evidence is very heavily pointing towards those NPSs, which we also know are specific to a particular type of infrastructure as opposed to critical infrastructure more broadly. And does that indicate to us that we might need to treat elements of critical infrastructure differently in particular?
I think there will be some circumstances in the district plan that you may need to, and it really depends how the provisions unfold. In the context of Gore, the Southland RPS has taken a more general approach, and other jurisdictions, for instance in Canterbury, the National Grid stands alone in the RPS as well, whereas the direction you have from the Southland RPS is more general, so that general approach was accepted through that process. That said, there are particular circumstances where I'm sure you will hear from me saying just treat the National Grid separately. One, by way of example, one of those might be when we get to anything in Indigenous biodiversity, and that's because not only is there an NPS for electricity transmission, there's also an direct exception in the National Policy Statement for Indigenous biodiversity for the National Grid.
Because that was sitting around that term critical infrastructure and the RPS, we've got reference to regionally and nationally significant infrastructure. It's not defined in the district plan, but when we look up to the RPS, there's some definition in there of regionally significant infrastructure. Do you have a view on whether there's some clarity required, or how consistent we need to be with the language of the RPS in this regard?
Typically when I'm in processes like this, when you start to have a definition of regionally significant or some type of important infrastructure, if you like, there's an element of Me Too about it, and the list becomes quite comprehensive. That said, it probably most typically would land at there being a definition. From the perspective of the national grid, there's never really any question about its importance. So whether or not there's a definition is less critical from the perspective of Transpower's submission.
And perhaps it comes down to where some of these terms overlap and where there are differences.
Yes, and there are a number of regional policy statements that seem to have overlapping definitions.
Because I was thinking about the regionally significant infrastructure, we've got reference to network utility and lifeline utilities and critical infrastructure. Those are the ones I can think of. Yeah, only some of which are defined.
Yeah, I always look for opportunities to rationalise those in evidence, but you're right, there can be a number of definitions, and it's a question of whether the provisions of the district plan need to do different things for that different infrastructure.
And that's something we might keep an eye on as we go through, perhaps.
Yes, I think Energy and Infrastructure chapter hearing will probably traverse that.
So with the inclusion of and the direction of the MPs, the inclusion of minor upgrading, maintenance and development at this stage, Transpower is reasonably satisfied.
You're referring to the UFD XX, yes.
Mm-hmm.
I think that the opening clause may need to be expressed in a way that's an outcome as opposed to more of a policy expression. I wonder whether clause 1 ought to refer to managing adverse effects a bit more generally rather than confining it to sensitive activities and sensitive environments, because the national grid will have adverse effects on things other than those. And I think that clause 2 needs to refer to direct effects as well as reverse sensitivity effects. Typically I would draft that by saying avoiding effects, comma, including sensitive and reverse sensitivity effects.
Any more questions?
I do, but I'm happy to let Keith go.
No, while I get organised and see Glenys has got her mic on.
And this might be something for both of you, in terms of the definition of small scale and large scale and the reliance on the 20 kilowatt threshold, the trigger. Can you bring anything to us that would help us understand why that threshold or trigger might be what's required for the threshold between small scale and large?
Is that related to
Renewable.
electricity generation?
Yes, it is.
Yeah,
Good point.
not, yeah.
Yeah.
We're probably not the
You're
experts
not
for
the
you on
ones
that.
who can help me with that.
Yeah.
Not the ones who can help. Thank you. Thanks for the reminder. Then it's probably just looking at this. Maybe this point I can see the response that's come through. Now I've just got to find it again in the amended provisions that are picking up the fossil fuel, moving away from fossil fuels, which was something that you were pointing to, and now I can't find it. Anyway,
Page 18.
page 18. Oh, I still can't. Must be blind. Oh, yes, there it is. Oh, yes, because it's sort of buried in there a little bit. Yep. Because I did originally have a question about whether there was a gap in the RPS when it came to the climate change mitigation element and the decarbonisation element, and that was coming through very strongly in the evidence from Transpower. So I'm going to ask, besides this amendment here, does this address any potential gap in the plan? Is there anything else that might be needed if there is a gap?
My response to that as a planner would probably be the scope of Transpower's submission will likely confine the
Yep.
extent to which the plan can respond.
Yep.
Certainly things have moved relatively quickly in climate change response, and the plans around electrification and Transpower's submissions are probably evolving slowly more slowly than the policy environment to respond to that.
While we're on the objective, so it reads, take into account the short, medium, B, 5B, provides for the transition away from fossil fuels through increased use and development of renewable resources in the national grid. To me, the the objective probably ends after the words fossil fuels. By saying through, that is the implementation phrase and should probably be picked up as a more directed policy rather than as part of the objective, because you could also have a transition away from fossil fuels by more efficient energy use and people relying on things themselves. So with these extra words, the second half of it, are you actually limiting the way that an objective of reducing reliance on fossil fuels can be implemented?
I would agree with you, and it could be achieved through latter chapters with a full stop after fossil fuels.
Yep. Now, sorry, your changes to point 10, so looking at page 10 of your statement under B, and I picked up, I think, a little bit of discussion. So number 10 there provides for a resilient critical infrastructure network to meet the needs of the Gore District, Well, surely as an objective, we should be thinking a little bit wider than just the Gore district.
Which page?
And
So,
on your
Oh,
page
my
10 of your
evidence.
original evidence. So it talks about the district develops a cohesive, compact and structured way that provides for the needs of the district, in summary, but in developing or providing for under the wider objective, surely we've got to think beyond our own boundaries.
certainly.
And that was as a further
Yes.
submission on the New Zealand Transport Agency's one.
Yes, I think perhaps the opening clause of the objective confines it to the district in some case, but I certainly would support a consideration of the wider contribution transmission lines in Gore, for instance, make to electricity supply across the country.
That's all I had, thank you. And final question. On page 8 of your statement, your paragraph 35 in the second line refers to SOs and SPs.
Environment Court terminology, strategic objectives and strategic policies. Thank you. Thank you for your time. Do you want me to respond in writing to the supplementary evidence, or looks like you've got it? Yes.
I think it's always
Just a quick supplementary statement that says,
Yeah.
I mostly agree.
And look forward to seeing you again. I liked in your evidence where you made reference to the paragraph number in many cases to what's in the Section 42A report. If you can continue to do it, given we've got so many different documents, that would be helpful. Thank you.
I know the problem. Yeah, I certainly will. Thank you.
Thanks very much for your time.
On. There we go. Yes. Well, firstly, thank you for hearing me today, and good afternoon now, I see. So we're getting into things. I see my submission has got slightly shorter. I've obviously overlooked a point reference during the thing, so it's something probably to do with doing this at about midnight. after trying to do a day's work and deal with 4 children. Anyway, so I'll read the submission, and then if you've got any questions, I'll leave out the gap that, as Matt suggests, is that.
Thank you. We read your submission, so we're happy to, if we anticipate you give us a verbal summary to your written submission.
Okay, I'll read what I have anyway, and then, yes. So my name is Hamish Weir. I am a licensed cadastral surveyor and registered professional surveyor, being a full member of the Survey Spatial New Zealand, with 19 years of experience in the industry. I am here to represent the Gore District's constituents in respect of the proposed Gore District Plan, PGDP, from the perspective of a local RMA practitioner, having been active in the Gore District since 2015. The following points address my submission and further submission points made. So financial and development contributions in respect of submission 69.8 and my further submission 5.6, where I opposed in part and disallowed in part. So contributions have long been a source of controversy. I have recently been involved in a Central Otago situation where funds taken for the purpose of upgrading a sewer pump station were not spent on doing so, and have now devalued to the extent that they will fall well short of current day cost of same. The operative, which I haven't explained, but the operative Gore District Plan's financial contribution section was put into abeyance by councillors due to the suppressive effect it was causing on development in the district. If they are to be reintroduced, then careful study of the impacts of doing so should be undertaken. If implemented, mechanisms to ensure the funds are spent for the purpose taken in a timely manner should be instigated before contributions are taken. The value of any contributions taken should be specific to the development proposed, accounting for only changes and acknowledging existing baselines. Consideration should be given to the application of such by adjacent councils in terms of value, to ensure competitive advantage is not lost. In terms of subdivision, this will prevent potential developers proceeding while stock of consented non-contribution subdivisions work through the system. This will inevitably result in reduction in supply and following increase in land value. Further land value increases will be incurred directly by the payment of contributions. I gladly acknowledge the officer's partial acceptance of this submission. So forestry, submission 85.1, my further submission 5.2, oppose in part and allow in part. So forestry, where potential exists for carbon farming, whereby the exotic trees are planted with no intention of harvest, is a significant risk to the Gore District, Gore District's less productive rural properties. If established, these forests create fire hazard, deplete valuable rural jobs without creating new ones, and often increase spread of wilding species through sensitive environments in the district. The Environment Southland submission goes a step too far by proposing prohibition, as the right tree in the right place is still appropriate. For example, steep gullies on farms which are inefficient to graze. The issues arise mainly in the rural zone. I would propose a rule forbidding carbon farming in the district and requiring silvicultural plans for all continuous forestry of 5 hectares or more. Additional rules should be added to the rural zone chapter to control the extent and locality of forestry within the district, as opposed to an outright ban. A new PGDP chapter is an excessive request, so I partially agree with the officer's rejection of the submission by ES, but want my concerns reforestry to be recorded. And we'll skip the engineering one and come back to that in another time. So if we go, I think, hopping over to submission 147.26 and further submission 5.8, support allow. The operative Gore District Plan is considered to be a permissive plan, and in my opinion has served its purpose well. It has been generally less cumbersome than the adjacent Southland and Clutha plans, often providing comparatively more streamlined and cost-effective processes. Times have moved on, development activity has increased, and some tightening of the rules was always to be expected in this process. The default settings of the PGDP to apply non-complying status to the majority of non-conforming activities is, in my opinion, a swing too far towards a rigid planning regime. The current plan's default discretionary status has been fit for purpose and does not need a reset. In many instances, the effects of non-conformance with the PGDP rules or standards does not constitute an activity that has significant adverse effects. Non-conforming status will result in future processing RMA planners to be excessive in their assessments, while often requiring unnecessary reporting and implying unreasonable conditions. I have in my submission and further submission generally identified rules when non-complying status would be reclassified to discretionary. But in general, I appeal to you all for a reset of the default to default discretionary for the PGDP. I disagree with the officer's recommendation of status quo without non-complying and implore you to further scrutinise this stance. And the rest of it is just my submission points. So, nice and short. It's vague. There's a lot of issues within it, not at a theoretical policy level, I suppose, but when the rubber hits the ground, when we are dealing with especially graduates, a graduate planner that picks that up on their desk and follows the plan and finds it to sit in the non-conformance status will automatically default to pulling a magnifying glass out and excessively researching things before a senior person gets to it, I suppose. And the more I'm seeing graduates, well, it's becoming very frequent within the industry to see graduates come out into council straight from university with very idealistic perspectives and applying very rigorous assessments to things that are non-complying, well, that are deemed non-complying under the district plans that I'm dealing with. And a lot of it could have been avoided if it was discretionary. I think it would change things in their mind. It often ends up that the application is assessed in the same way, I suppose. You know, it doesn't actually change anything, but it does in the planner's mind when they're looking at it, is my problem, I suppose. And the RMA is, well, from what I understand from the other RMA lawyers and things that I've been working with lately, it is a point of contention anyway, discretionary and non-compliance, and the difference is there can be a lot of vague space there.
Thank you, Hamish. I really appreciate that. I Mr. Weir, but he has assisted me in the past in his capacity, so I appreciate that and just acknowledging. So when I look at what you just put down around discretionary and non-complying, it seems to me that you might actually be flipping things around and saying, unless there is a directive need to go to non-complying status, perhaps because we've got some direction from above to avoid or protect something, so it's where non-complying status might be appropriate. Is that a fair summary of what I'm picking up? As a, you know, so that you're suggesting a discretionary catch-all unless there is a specific directive or reason.
Yes.
Yeah?
Yes, I agree with that.
That's a fair summary. I've got quite a bit that I want to canvass with you around the forestry point, so I just want to check to my left if there's anything before I run down that.
Well, my questions as well relate to forestry.
Jolly good. So I'm looking at the NPS HPL, highly productive land, where there's a definition of land-based primary production. It differentiates itself from other primary production like mining, and forestry is included. And highly productive soils are to be protected for land-based primary production, including forestry. But I guess I'm interested in the ability to, for a district, to differentiate forestry types within that picture. And what I see coming through your submission is this idea of being quite targeted about right tree, right place, what kind of forestry do you want, and where do you want it? And I didn't see anything in the MPS HPL that would prevent some differentiation around forestry being provided for on those lands, because you may not want to lock up those lands in long-term forests. Yep. So when I read your paragraph 11, where you're suggesting a prohibition on carbon farming, and then my question to you is, would that depend on what your definition of carbon farming was and what you're trying to differentiate? So maybe if you can help me with that a little bit.
Yes, Pia, that's a good question. So yeah, I guess it's pretty topical amongst all, so I'll take it back a level. Where's this come from? Peers of mine. Lawrence is a great example, right? It's tragic. The communities, that extended community was quite a strong one. Now it's being ripped apart around the fringes, and with the carbon farming basically in effect is what a lot of those pine tree expenses are going to become. A lot of them don't have any silviculture. There's clearly no tracks been installed. They don't look as though a lot of them have any intention to harvest at any point. So we've had some jobs created to do some planting, then we've had nothing. And now we're going to have some pine trees that sit there. Some of the concerns I know around this are that there were no protections reinsurance of those trees. Should they burn down, the carbon is emitted and then becomes effectively the taxpayer's problem to account for, which is even makes the situation worse, really, in my view. So we have no jobs, we have I don't see a benefit. This is basically what I'm saying at all, and I see a liability. So and also having known people, young farmers trying to personally get into land in places and having to compete with that, it's always going to win because of the way the politics are. So if the regulation, I guess at a grass level, I mean that's what's important, I suppose, about local governance and local regulation, is that it allows some probably protection against some things like this, which are not apparent issues to urbanites. These are not things that they will understand because they don't affect their daily lives and they don't affect a lot of people they personally know. Whereas I guess in a district like this, we all know a farmer, and we all know a farmer trying to start somewhere and get a foot on the property ladder. So this is where, does that build the picture? And so yeah, when you come down, you're right, I'm being a bit vague and there's a lot of things around that. What I'm trying to do is raise attention to it and saying, is there some way that we can make it kind of clear that this plan, to a potential investor that's looking to come in here, buy a tract of land, plant pine trees on it and do nothing with it, is there a warning sign that we can send to them that will identify this and put them off and make them look elsewhere? Is really where I guess I'm coming from.
And so would that be through some defining and differentiation first of what is desirable in the district and what is not?
Yeah.
So that requires a definition or some differentiation there, and then either carrying that through provisions or undertaking some kind of spatial I think we're probably,
Probably
Yeah.
not the spatial planning. I think that's
Yeah.
too much, and I
Yeah.
think it would be too difficult. We know that we've got that problem. The HPL has thrown everything into utter chaos, to be quite honest. It's a daily problem for me tearing our hair out because of the lack of interpretation. So yes, I think interpretation this section is probably somewhere that we could start to look for initially. Yes, spatial plan of it, I think probably too hard.
so we're looking to differentiate and define and then carry through provisions.
Yes, I think so.
And of course we have to give effect to our MPS, and so it's the extent to which we've got latitude in giving effect to that.
Onto it. Yes, I guess as my job is this, to find a way through the process, and I guess that's what I view the commissioners here being tasked with, to find a way through meeting the objectives of the MPS while still providing what protection we can.
Can I just ask a question in terms of prohibition on carbon farming? And I guess I want some feedback, from the legal team. We have a submission from Environment Southland that wants control chapter on new wilding exotic trees. We have a further submission that says, don't agree with that, but you should have a rule prohibiting carbon farming. And I don't think it's within the scope of the original submission that was lodged. And unfortunately, I can find no reference to carbon farming amongst any submission lodged to the district plan.
Yes.
I haven't reviewed the submissions in detail. I would note that carbon farming is captured by the NES in terms of the definition of commercial forestry is probably where your starting point at present is for the regulation of carbon forestry. So anything that you want to do beyond that NES, I would agree, would need to be in reliance on a submission. So are you asking if there's scope to prohibit carbon forestry?
Well, I'm actually taking the opposite, suggesting that we can't make the change that's requested because I think it's outside of the scope of the original submission, but it is the same question.
Certainly in terms of further submissions, they cannot enlarge the scope of the original submission. So that is where that summary is provided in the legal submissions. So it would be for you to interpret that, I think. And I would probably also wish to double check all of the submissions. Is there a topic that would fit under appropriately? Because it probably doesn't fit within the scope of this particular hearing very well, but we can certainly make a note to come back to it.
I think this is probably the hearing that it does sit within because we haven't got,
What, that provision?
yeah, potentially rural.
Yeah, maybe rural. Yeah.
Is it indirectly defined? We got reference to production forestry, which gives a definition around that, but wouldn't extend to carbon farming, and by default would exclude carbon farming.
Yeah, and this is a tricky definition, which happens a bit. The NES was amended recently to capture carbon farming because it was directed only to productive forestry, but now captures the scenario where then there's no harvest. I would suggest that the rural, if the submission has been made particularly in respect of wilding in the rural zone, perhaps that's one to be reserved for that. I wouldn't anticipate it, because it is an activity that is undertaken in the rural zone, and as I understand Mr. Ware, he's talking about effects on the rural zone, so it's probably considering.
So I'll add it to the list of things that we would want in the right of reply, just in terms of where that issue sits.
Yeah, thank you, I've noted that.
Hamish, you know the area. There isn't a lot of areas where somebody would undertake carbon farming, surely.
Mount Wyndon, all of it, the whole thing.
Okay.
All of those farms out there, up on the sides of Waikaka Valley, whole way. Yep,
Okay.
most definitely. They're not I can't see who would be able to afford Mount Wyndon Station, other than that, for example. It's not an outstanding natural landscape either. So something to think about, that whole valley and what it might look like. In fact, I know one of the landowners on one side, I could see him doing that. He just hasn't thought about it yet, or known what kind of dollars he'd get for his particular bit of land. And it's, so this stuff lies, it's not, oh no, it falls, some of it falls north too. It's not a lot of south in it. It's quite a nice, easy contoured farm, but I could think it would be an example.
I didn't realise that whole, on the way to Lawrence was cow.
It's probably not all, but I can see because of the lack of civiculture, you can't see the tracks. There's no track. They don't, that would cost. They've probably looked at an upfront cost of tens of millions in some of it in terms of the digger work and things involved and the consents required to do a lot of that. And so why would they do that?
Through you, Mr Chair, would you also add like a fire risk?
Yeah, the fire risk, you're right, sorry, this is in there. The fire has two effects. One, the trees are gone, so where's the carbon? Who has to account for the cost of that? And two, yes, the hazard. We saw it in Nelson. I'd lived there for 4 years. I know they were running into some big trouble if that one got further. It would totally cut the whole basin off, and that would have been a lot worse than the portholes environment.
And weed and pest.
Yep, pest as well. Yep.
Word in point 12, you've got control the extent and locality. Is that meant to be extent and
Yes.
locality? Oh, I gathered that's what you meant, but I'm just clear.
Again, late at night, I think. Yes.
Are you opposed in principle to financial/development contributions, or just asking if they are adopted that the process that's set out on the Act of justifying it is very thorough?
Yeah, I don't think, a bit like the right tree, the right place, Keith. The right contribution, the right place, used for the right purpose. But that example in Central Otago, it was raised at the plan change process that was sitting through there. They've since managed to scurry it away, but it's because I don't have access to my emails from my former employer that would prove what was said. So I have a problem. There's a disconnect too between an engineering department or a functional management part of council and a regulatory. The two are not linked well. So information that's accepted at a planning level is not passed on, which is effectively what's happened, I guess. So, yes, right contribution, right place for the right purpose is fine.
Yeah, just to expand on a contribution for the right purpose, you're really excluding residential subdivision and development by that.
No, not necessarily. No. If I propose a 100-lot subdivision at the end of an existing street that is, going to have an obvious impact on, say, a sewer is probably the easiest one to point to, then, a contribution for that sewer upgrade. But what I don't want to see, which is what I constantly see, is that money is not spent on that sewer to do that job. So it gets ferreted around somewhere else, and then we end up with an issue in the future when everyone starts contributing to that said pipe. And I was it's frustrating, I guess, because the money is not spent at the point in time it depreciates to, well, not depreciate, inflation destroys the value of it. So it's a problem. But then as a counter to that, also stormwater, should the developer then go, such as Matai Ridge put in detention to withhold flows and maintain current flows leaving the site as prior development, then I don't know whether the stormwater contribution is appropriate in that instance, because they've paid for that. So see, does that? But
Yes.
water is another one, obviously, potable water. And obviously 100 lots would have a big impact on an existing main, and you would see sometimes it's more practical, and council would potentially get better value out of having the contribution and contributing to the upgrade of the main down there rather than having the developer do it, because they may already have had they should have already been depreciating that main, have some money set somewhere within their RAM system saying, right, this main is 50 years old, so should already be a value there for this to add to have it replaced, I suppose, as an example.
So a policy that allowed you to levy a contribution on that activity but go to the wider servicing infrastructure, so that it's not sitting there on the shelf devaluing?
Roading, you could argue that the road at that point isn't going to be impacted by the 100 lots, because it's in Gore we already have very wide streets anyway, so probably maybe the increase of traffic will have no effect. And yet, at an intersection, say a kilometre away, it may have a profound effect. And the intersection needs upgraded. And yes, you could see then, even though it's not directly attached to the site or whatever, it's still, in that point then, yes, I would sort of agree. Otherwise, because I've seen it so much, the money doesn't get spent, Cliff, is the problem. I think that's what I see. The money needs spent, and having it targeted to something that needs to happen when it's agreed to happen.
I'll give you an example. Wastewater capacity. So you levy a contribution to enhance wastewater capacity, but there's only one lot developed amongst 20. But that money could be spent immediately on stormwater separation, which would enhance wastewater capacity.
Particular issue for the district, yes, I understand. But it leaves a problem for the development that's happened, because it's happened on the presupposition that work will be done. Otherwise, the infrastructures, and this is what's happened in my particular Central Otago example. Now I have an under-capacity sewer pump station that I'm proposing more lots for, and considerably more lots for. But now the cost of dealing with that is enormous compared to what it would have been at that point in time. Yeah.
Any more questions?
Other than to note there are provisions in the Act with the situation you're describing. Financial contributions are not paid, spent within a certain amount of time or for the purpose. It was helpful in your submission, particularly where you put in the headings of the submission numbers. It would be even more helpful when we hear from you the next time if you can also refer to the paragraph number out of the reports. Just makes it so much easier for us to flip from one to the other, please. As I said, we look forward to your further contributions.